Any mentioning?
Yes, Lord, what mentioning is there. Lord, item number 31 of the regular bench matter. Old suit. Lord, I have now filed my application for amendment. What was due, my Lord, on the last occasion, my Lord, my other side was objecting. But now, my Lord, tomorrow it is due to appear as GA number 15. So Lord, I will be only praying that this matter may be adjourned till the disposal of that particular application, GA number 15 of 2023. I have not been able to keep
tomorrow.
My Lord,
GA 15 is fixed on tomorrow.
appears to be, my Lord, that appears to be, it is to be taken up. Item number GA 15 of 2023.
Now today 31 you want, so adjournment in respect to 31.
Item number 31, my Lord. For any time, my Lord, 7 days or whatever.
All right. I will take care. When the matter will be called, I will adjourn.
I am grateful, my Lord. If I am not here, my Lord.
Origin side commercial division for arguments. Item number 1.
My lord, I have a. My lord, I appear for the defendants one.
Lordship, I appear for the defendants. Mr. Bhattacharya is appearing online.
My lord, I have an application.
My lord, I am appear on behalf of the plaintiff in this matter, my lord. On last occasion, Lordship fixed is for argument, my lord. In the meantime, they have filed an application for recalling the order dated 12 July 2023, my lord.
Yes, my lord.
So they want to examine the witness.
You want to cross-examine the witness, my lord.
You want to examine another witness?
No, I want to cross-examine
We
the
want
witness.
to cross-examine my witness, my lord, plaintiff witness. Lordship, kindly see one list of dates, my lord, before taking their application once.
My lord, it is my application. May I?
This is your application.
Yes.
Lordship, Mr. Bhattacharya is not audible. Maybe.
My lord, this is my application, my lord.
You are defendant.
Yes, defendants 1, A, B, and C. I have been substituted in place and stead of the original defendant. The original defendant was my father. My lord, this suit was dismissed. Their restoration was dismissed. The witness was being examined. Then I raised an objection as to the admissibility of that document. My contention was rejected. I go up to the division bench. Justice Sanjeev Banerjee upholds my contention. However, that is set aside in the Supreme Court. Thereafter, the matter appears. My lord will kindly see paragraph 13 onwards.
No. What do you want right now? Only that.
Only, my lord, this order be recalled so that I can cross-examine their witness, PW1.
Yes. What do you have to say?
My lord, Lordship, kindly see the list of dates, my lord, once, my lord.
What is that?
So many dates appears in this matter, Lordship. They had never come before this court. They don't care to come over here.
My lord, why I did not come? Your lordship will kindly see.
Counsel, my lord. There is an advocate on record, Lordship.
My lord, kindly come to page 82.
Delay in these proceedings, Lordship.
Because the
Lordship,
matter.
kindly allow this. And
My lord,
also,
kindly come to page 82. I was hospitalized between.
no, advocate on record, they are there. He is
I
counsel.
said why the advocate on record could not come.
On last day,
Mr.
he is coming.
Bhattacharya, he is not objecting to, only subject to cost. That is his
Yes.
submission. He is not filing AO.
My lord.
And Lordship, I am not admitting, my lord, any allegation. Lordship, kindly record it. That's
All
why I
right.
am not submitting the evidence.
Without admitting any allegation, you have no objection if the part is allowed.
Yes, Lordship.
Subject to payment of cost. That is the contention. GA number 6 of 23 is filed for recalling and or modifying the order dated 12 July 2023 passed by this court, allowing the learned counsel for defendant number 1B, 1C, and 1D to cross-examine the plaintiff's witness, semicolon, permitting defendant number 1B, 1C, and 1D to adduce evidence and then to
No, my lord, first to cross-examine the plaintiff's witness. First to
yes,
cross.
that I mentioned, you patiently hear my dictation. And then to hear the argument. The learned counsel appearing, next paragraph, the learned counsel appearing for the plaintiff submitted that his client or clients,
Client, my lord.
client does not intend to file affidavit in opposition, but at the same time, he does not admit the allegation raised against him. Full stop. However, his contention is the petition may be allowed subject to payment of cost. Next part. This court, therefore, is of opinion that since the prayer is not objected to, and since allowing the instant prayers will not cause any prejudice, prayer A and B are allowed on payment of cost of rupees 5,000 to be payable to the High Court Legal Service Committee before the returnable date. Which all the plaintiff's witness you want to cross-examine?
No, there is only one witness, Mr.
What?
Rajendra Kanodia.
PW1 shall be present in this court on the next day to face cross-examination on behalf of defendant number 1B, 1C, and 1D. The suit will appear in the list under heading witness action on
Lordship, I am praying for very short date. Lordship, my witness is ready, my lord.
My lord grants me 2 weeks, my lord. I tell your lordship because
4th September.
Lordship,
4th
Please.
September.
Wait,
What?
wait.
I will not be here for 2 weeks. So
Lordship.
I cannot fix any earlier date.
My lord, would it be a lordship to fix a time, my lord? Because I am in some medical problem, my lord. If it is your lordship,
The first is the list at
Right.
10:30.
I'm great.
I'm good.
Regular list. Item number 1 and 2.
This came, my lord, at my instance. My lord, the recording of evidence with respect to, my lord, 2 suits are going on by way of commission, my lord. My lord,
You are
that,
defendant.
that, my lord, is expiring, my lord, on 21st of August. Now, I understand, my lord, your lordship will not be there, my lord, for 2 weeks.
Any objection?
Let this, my lord, this be extended, my lord, by 6 weeks, my lord.
8 weeks ago.
8 weeks হলে আবার সেই ওটা আবার এসে extension করে 10 weeks হবে। 6 weeks থাকলে 8 weeks হবে। The problem, my lord, is the commissioner is not an arbitrator. He cannot enforce the dates. That is the problem. Let it be 6 weeks, my lord. If not,
On
then
prayer
it's
of the
not
learned counsel of
Will
both
come
the
back.
parties,
My lord, let it be 8 weeks. Because I am cross-examining now. And then they will
Do it
examine my
quickly.
witness.
don't delay.
No, I'm not delaying.
You will know. Parties, time is extended for completion of witness action
পেনে লিখে অভ্যেস নেই আমার। হ্যাঁ
3rd October.
8 weeks.
Third October.
Third October.
I'll give you. New chamber applications, item number 3 and 6.
Lord,
Uh,
I appear for defendant number 1A, 1A and 1B, my lord, in this matter.
My application for the GA number 2099.
GA number 20 is your application.
Yes, my lord. The application for substitution of the defendant number 2 who died on 17th March 2023,
Shailen Datto.
Shoren Datto.
So
his
Shailen Datto
wife-
is to be substituted by,
His wife, his daughter, and his son.
you named there.
Yes, I have named therein. I have in my annexure B at page 14, I have indicated
Someone took the master someone took it.
at page 14, my lord.
Is it partition suit?
Yes, my lord, it's a partition. suit.
Have you any objection?
No, my lord, I don't have any objection. It's a formal application for substitution, my lord.
And the
What as
number,
18 is concerned?
My lord, 18 is my application, my lord, 18 is my application. If your
But if-
lordship allows me, I can place it.
Let
the
me,
whole issue is that under this amendment is not carried out,
18
is-
cannot be heard.
cannot be heard.
All right.
That is an issue because in this prayer, I have made a prayer for substitution of the defendant number 2 A, B, C. The defendant number 3 has changed his residence, his change of address. And I've also made a prayer for service of fresh writ of summons on 2 A, B, C, the prayer F.
Appointment of valuer.
No,
Lord,
No.
18 is appointment
at
of,
18 it will value.
18 is appointment of valuer, my lord. 18 is
Formalities are not completed.
that cannot be heard.
I possibly that application cannot be heard. my
Then
lord.
added party must make some objection or something like that. So that should be opportunity should be there. GA 20 of 23 is filed by the plaintiff praying for recording death of defendant number 2 substituting defendant number 2 by his legal heirs, and successors, he's getting up, along with other prayers. The learned counsel for defendant,
1A and 1B.
1 A or 1 B.
learned counsel for defendant number 1A and 1B did not raise any objection. Let prayers
A, B, C, D.
A2. Now, আরেকটা কথা লিখো, since this is a partition suit, there is no question of the right to sue survives. There is no secret. The right to sue survives. Let prayer A2
G, my lord.
G of the master summons be allowed.
I am appearing on behalf of defendant number 5, 6, and 7.
Give a sleep. Have you any objection?
No. So
Defendant
with
number
regard
1A,
to
1B,
substitution,
and defendant number 5. You are 5,
6 and 7.
5, 6, and 7. Raise no objection. Department is directed to do the needful in the meantime. Fix 15 September as returnable date and hearing of GA 18 of 23.
I'm grateful, my lord. I'm grateful.
Would you like to file any AO?
Yes, my lord. If there's, I'll file in the meantime, my lord.
Affidavit in opposition
Application. We get it, no.
against 18 of course,
Okay.
unless these things are done, you cannot do this.
No, my lord.
Formalities are done, you cannot do
And
this.
a direction may be given upon the plaintiff to serve the amended plaint upon the.
That is there, that is allowed. That formalities are to be done. On returnable date for further order.
My lord, he can, my lord, subject to correction, my lord, he can file his affidavit with the new cause title that he has annexed with the substitution application.
Let those exercises be done first.
But with due
Very
respect,
well,
the amendment is not carried out. I can-
Yes,
Very well, my lord. Very,
Perhaps he has to serve the application to other side also.
yes.
very well, my lord. Very
I cannot
I'm
fix it
grateful.
right now.
well. I'm grateful, my lord.
Yes. So GA 20 stands disposed of.
Yes, chance
Yes,
disposal.
my lord. Yes, my lord.
18th sanctioned 18th, 15th
Yes.
September. Obliged, my lord.
Returnable date. G18 will appear in the G18 of কত বললো? 18 of 23 shall appear in the list on the date.
I'm grateful. my lord. I'm grateful.
একটু দেখতে হবে বন্ধ করে শুধু রিপোর্ট করে কথা বলি স্পিকারের সঙ্গে
Item number 4 and 5.
My lord, in this matter today, my lord, the receiver special officer has come before your lordship, that the conveyance has been executed, they have complied the thing, that they let them, both the applicant be disposed
Have
of,
you filed anything? Filed any report?
I'm carrying the report.
Report of the,
let the report be filed before your, in the court. Item 4.
This is for item 4.
Item 5, my lord.
item 4 is here, my lord.
Item 5, that means GA 97.
Yes.
And 96 also report is filed. Cause title টা দিয়ে দিয়েছি both matters সাথে। ওইটাও দিয়ে দাও, judge সাহেব। And this is 97, my lord.
Just a minute. One by one. 4. Item 4 এ লেখো এটা GA 96. The learned advocate, public special officer, Srimati Priyodarshika Gupta, filed report dated 7th August 23, wherein it is stated that pursuant to the order dated 8 June 23, read with order dated 20th June 23 passed by this court, deed of conveyance was registered on 10 July 23 before the additional register of assurances 3 Kolkata in respect of the aforesaid flat. Full stop. Her remuneration has also been paid. Let the report be kept in record. Full stop. Since the order has been executed, let GA 96 of 23 be disposed of. Stands disposed of.
Deeply obliged.
Be obliged, my lord.
It's same order for ওই একই অর্ডার হবে, এখানে নামটা আলাদা হবে। The Planet Council submitted report pursuant to Mr. Gaurav Purokayasthu, learned advocate of the special officer, Sri Gaurav Purokayasthu, এটা GA 97 of 23. Submitted report dated 8th August 23. Wherefrom it appears that order of this court dated 8 June 23 has been carried out and the deed of conveyance was registered with the competent authority. His remuneration has also been paid. The GA 97 of 23 be disposed of.
I'm grateful to you.
Report be kept in record.
Item number 7.
It's item number 7 and 8, my lord. In 7, I beg to appear for the respondent number 5 and 6. And in 8, I'm for the respondent number 12 and 13.
My lord, in item number 7, I am appearing on behalf of some of the respondents.
Who is the plaintiff?
Mr. Chok. This is Chakraborty Chatra, Jhuma Chakraborty Chatra is appearing for the plaintiff.
Where is she?
Without taking NOC of my advocate, on record, how can you appear?
My lord, first time appearing, my lord, previously one learned advocate.
We have
Just a
been,
minute.
One learned advocate appearing, my lord. My lord, I have not yet received the, my lord, no objection
Then-
from the erstwhile learned advocate.
Then I will not take into consideration.
yes, my lord, the problem is that, my lord, last occasion, kindly lordship, kindly
Where is
recall.
the plaintiff? Let plaintiff come first.
No, my lord, I am just raising a technical point regarding his appearance, my lord. Now, my lord, the constituted
No
attorney.
objection certificate, so I'm
Yes,
not
yes,
considering
yes,
it.
yes. I'm grateful to your lordship.
What about this application? Who filed this?
Lordship, kindly recall lordship last.
Are you in this matter?
My lord. I am in GF 16,
15?
15 and 16. In both matter, I am appearing.
There is a direction of serve of press copy upon me.
Yes, I have served, my lord.
Only copy of the 15 I received
Yes,
by me.
15, that only 15, there is a wrong pagination, my
No,
lord.
no, 16, the same thing has been happened
Not
to the
16.
16.
But
There is a
direction
direction
upon
to serve the 15
15,
and
my
16
lord.
both.
Not
You have
15
not
and-
received copy.
No, I have received only 15, my lord, not 16 has been served upon me.
Sub copy, do it. Why you are sitting not
No.
keeping the controversy open?
No, no,
While
where is
Last
the order?
occasion they have
Show me the
taken time. আরে দশটাকে order আছে দেখো না
My lord, only
সার্ভিস করার
15.
প্রবলেম ছিল কথা ছিল
Because,
সার্ভ করতে কি প্রবলেম আছে
no.
Then?
My lord, 15 and 16, we relying upon the GA 15, my lord, because every averments we have taken in our pleading in GA 15. My lord decided to take adjudication
Yes,
on
so far as
yes,
16
my
is
lord.
concerned, there was a direction to hand over copy.
yes
There is a direction.
the
You'll suck it.
discrepancy is both the GA
Suck
application
it. This is that power of attorney case.
yes
Out of
yes
my-
yes
my lord.
You serve copy and come on the next date.
My lord.
otherwise my pleading is already complete pleadings are completed my lord, kindly fix a date for hearing then
Learned
In the
counsel appearing for
I am for the my lord, respond number 5 and 6 in respect of the GA number 15
respondent number 5 and 6 in respect of GA number 15 and respondent number
and my
10
lord,
and
12
12.
and 13 in respect of the GA number 16
13.
12 and 13 pro forma
12 and
respondent.
13 in respect in GA number 16
I am appearing for the applicants, my lord.
জানি
submitted that they have not received any copy of
Just 7 and 8
GA16. You have not received GA16.
yes GA 16
GA16 of 23.
অনেক টাকা বাকি আছে তাই
Let a copy be served.
Sitting batch promoter
No, let now. On previous occasion, order was passed to serve a copy. Learned
In.
counsel for the plaintiff shall serve a copy of GA16 of 23 to the learned counsel to appearing for his on his other side for the defendants. The matter will appear in the list for hearing on
not except 24 August but any day except
will
24
not
August
stay here.
Copy দেয় না, কিছু দেয় না, yes. বাবা, দাঁড়া।
8 September, okay?
My lord,
8 September.
8 September. My, can it posted on 9 September, my lord? 8 September matter is fixed, my lord, at 10:30.
9 September.
10,
I
9,
will-
10, any day, my lord.
I will not come to the court because that is that
Before
is
that,
Saturday.
7, 6, 7, any day.
Will you come on Saturday?
No, my lord, any day. Before that week, my lord, 5, 6, any day.
6.
6. I'm grateful to you, lord.
Then you want to come on Saturday, I understand.
Item number 9.
My lord, in this matter, I am appearing for the petitioner and for the Shevats and trustees to the Devottor estate being situated at
I appear for the official
13
receiver.
Devendra Mollik Street
But
and
G3 is about
Sagar. This is with regard to an application which has been filed for discharge of the official receiver High Court from acting as a receiver and makeover and handover the management of the Devottor properties of the DT Sri Sri Ishwar Sridhar Ji and Sri Sri Ishwar Lakshmi Mata Thakurani as mentioned in the schedule, which is at page 12. The schedule of the properties are 13 Devendra Mollik Street, Kolkata
what are the
7,73,000.
grounds?
My lord, now there has been talks of settlement and it is in a positive note. My lord, official receiver has informally accepted our proposal of discharging his position from the property and hand over the possession to us, provided that there won't be any liability of the official receiver thereafter, and the official receiver. And
Who is the official receiver?
I am for the official receiver. He is for the official receiver. So the official receiver has desired that you file an affidavit to that extent that you are not putting any liabilities to us, and there will be, you are getting this property on as is where is whatever
That might be.
whatever
You
that
come
might
with
be.
an affidavit.
Yes, my
Getting
lord, that
official-
affidavit needs to be exchanged with the official receiver, which has not yet been done. So, my lord, kindly grant us some time, maybe a fortnight or so, that the official receiver
On prayer of the
consider
landed
this
council,
affidavit, and then
Consider and come back.
after he considers this affidavit, we will file it before this honorable court.
on prayer of the landed council for the petitioner as well as the official receiver, the matter is adjourned to 27 September.
27 September.
My lord, it's too late for 20 seconds.
My lord,
Maybe as the last
later,
week of
If
this
thing is
August.
ready,
It's ready.
mention it.
Grateful.
I will enlist.
Grateful.
I am giving you only time. This is only for time.
No problem. It's your lordship wishes. We
You
will
come
get back.
mention, I will prepone.
We will wait.
Grateful,
Get back.
sir.
Grateful, man.
Chamber applications for final disposal, item number 10, 11 and 12.
No, there is that substitution which is pending since long. Now, my
Got
lord,
any information on this?
My lord, in this matter, many things happened. I examined the documents. I have seen many things is there. Number on the property under receiver.
No, that's true, but substitutions are to be made.
the thing is what is happening now.
My lord, difficulties is this. In one matter, one transfer, he was taken leave from this court for sell this property. Similar transfer, subsequent one after another, they purchase the property, dependent number 7.
For the
But
timing,
without
at least
leave
some
of the
plaintiff
court-
must be there. Then let be transposition of plaintiff.
My lord, allow me. Has to be correct.
Yes.
My lord,
Or-
What is
some
now
plaintiff
happening?
must be
Roving
there.
and fishing inquiry is going on.
How long it will go on? Look,
My lord,
some plaintiff
If
must
he
be there.
can't, Millard, allow us to proceed, Millard, with Millard. I will carry out the substitution. Give me the liberty. I am defend number
Then
7.
let you be transposed as
Yes,
a plaintiff.
I will.
Who are you?
Defend number 7.
Not I am for different number 3B. What happened, Lord? Way back
Well,
in 1962, preliminary degree was
No,
passed.
do one
Even
thing.
today,
You come next day with an
final degree
application,
has
I
been
will
passed.
substitute you as a plaintiff.
Kindly, Millard,
You carry out the
record
necessary
that.
application.
Kindly, Millard, records that. And let the substitution
My
be
lord,
carried out.
before allowing this, my lord, 2 or 3 minutes, my lord, grant me to make my submission. 2 and 3. Number 1, my lord, if you have to look the
Mr. Das,
affidavit-
without application, I cannot consider all these things. Without your formal application, because problem is that suit needs substitution, plaintiffs need substitution, suit is without plaintiff. So
my lord,
transposition-
plaintiff should be substituted.
Yes.
But defendant now claiming many things. They are
I'm
now
not claiming
substituting.
at
anything.
least, I cannot consider their claims right now. At least substitution be made.
I'm
Let
not
them
claiming
be
anything.
substituted as a plaintiff.
Yes, I will proceed.
This much.
My lord, they are
I am not
demanding.
considering anything on merit right now.
What has been sold, not sold, Millard,
That I
minor
will
is there.
consider
That will be
that.
yes.
That is not
The suit
question.
is not there.
Only thing is, let there be someone as a plaintiff.
Allow me, Millard, kindly
This
record
much.
that. I'll file an application. Kindly, Millard, record
My
that.
lord,
You come up with your case, you come up with all your substance, objections, all these things. Thereafter,
I am
I am
defend
not
number
passing
7.
anything on merit. The learned counsel
Defend number 7.
for the defendant number 7, praise leave to file necessary application for transposition as plaintiff. Since Mr. Das, learned counsel appeared for the plaintiff, failed to carry out and file necessary substitution application. Leave is granted, let the matter appear in the list on
This month, when immediately Millard comes back, Millard,
30th August.
30th August. Obliged.
Copy dijo.
हाँ अरे करले तो दिए दो immediately my lord comes up we will Millard
Yes.
get it yes obliged
my lord,
10 to 12 10 to 12
I
Millard
am for 3B. Lord.
Give a slip.
Item number 13.
My lord, I appear for the defendant numbers 1A and 1B. My lord, on the last occasion, your lordship had granted me leave to file opposition, my lord. My lord, I'm seeking some time, my lord, because there was a number of papers, handwritten minutes of the meeting of the receiver, my lord, which I wanted to annex, my lord. My lord, we are getting it typed, my lord. We are out of time, my lord. I'm seeking an extension, my lord.
You are
Defendant numbers 1A and 1B.
defendant number, the learned counsel, Mr. Gupta, learned counsel appearing for the defendant number 1A and 1B. Seeks for accommodation and extension of time to file affidavit in opposition. Accommodation granted. Affidavit in opposition is to be filed within 2 weeks.
And whether
2 weeks,
My lord,
and affidavit in reply, if any, to be filed within 1 week thereafter. 1 week is okay.
my lord, I don't know, my lord, because my learned friend
much
says it's a
voluminous it will
voluminous
be?
document.
So on the strength of this extension, you will seek for another extension. That is judicial precedent.
I understand, my lord, very well.
You know. Let the matter appear in the list on 12th September.
much obliged.
Grateful.
13 and
13.
My lord, only 30.
Item 14 and 15.
My lord, I am appearing for in 14 and 15. I am appearing for the defendants in this matter, my lord.
Bharat Goenka.
Sharad Goenka. Sharad Goenka. I am appearing for Sharad Goenka. The matter, the compromise is it is going to get compromised, my lord. The terms of compromise has already been prepared. It is under settlement. The plaintiffs are deciding outside. So I am seeing if it is.
Instruction in that regard, my lord. If they want time
Well-
for compromise, I will not oppose.
When you
my lord,
submit
but-
it, let this be recorded.
Yes, my
What
lord.
is the stage of the suit?
My lord, we have filed one application under Section 8 of Arbitration Act because the agreement on which they are relying upon it itself contains arbitration clause.
Learned counsel for the
Defendant.
defendant submits that talk of settlement is in process and seeks for adjournment on this ground. The learned counsel appearing for the plaintiff submitted that
We have taken out a chapter 13A application, my lord, as
he
well.
has no instruction from his client in this regard. However, the matter may be adjourned for taking clarification and instruction from her client. Accordingly, matter stands adjourned till 21st September.
Much obliged.
For framing of issues, item number 16.
Your Lordship, I'm appearing on behalf of the plaintiff, my lord. I'm praying for one last opportunity, my lord, for submitting the suggested issues as well as the judge's brief of
Who is
documents.
the defendant?
My lord, it's an undefended suit, my lord. At present, nobody. is
Undefended
appearing.
suit,
No,
why
it is not. It is not, my lord. The defendant number 2 was represented. My lord, I don't see anybody appearing now.
Judge's brief of document has not
And
yet
the
been filed
suggested
possible.
issues, your Lordship.
Judge's brief?
Judge's brief of documents, one last extension, my lord, for both accounts.
Should I have for the defendant?
number.
Judge's brief of document, have you filed suggested issues?
Lordship, suggested issues have not been filed, but your lordship,
Judge's
My
brief
inst-
is not filed. possibly.
yes, your lordship, but despite repeated directions, they are not filing the judge's brief of documents.
Accommodation
we
is
have-
paid for on behalf of the plaintiff
Issues
to file judge's brief of document and suggested issues. Full stop. On previous occasion,
issues to the
number of accommodations were allowed.
issues.
Today, accommodation is allowed, subject to payment of cost of 5,000 to the High Court Legal Services Committee within 15 days. The matter will appear in the list on 30th August for filing suggested issues and judge's brief of document.
No, pleasure, your Lordship.
Cost shall be paid in the meantime. ঠিক আছে, আর ওই কথা কেন? ওই কথাটা কেন? 15 days টা কেটে দাও।
For hearing, item number 17.
May please, man.
What GA number 1 is about?
This is the revocation application.
Who is your other side?
My lord, I have already argued on 2 days on this matter. I have still to finish my submissions. Only one thing was that your lordship had, one of the main points that we took is that after probate is granted, the executor has to file his inventory. Then your lordship granted us leave. At least what we have seen, there is no inventory. My learned friends have also taken inspection, and the records, I believe, are in your lordship's court. So if they have filed an inventory, then I can't press that point. But we have seen there is no inventory. Therefore, the matter is pending. Therefore, there's no limitation. It is important. If my learned friend tells my lord if they are saying.
Next one. Your revocation point for revocation first is this one.
Yes, because under 263, this is one
6
ground.
months.
They have to file within 6 or till they have filed. I can challenge the thing. If they have not filed, then usually the executor is removed. The 2 consequences can happen, or the will can be revoked.
All right. Next point.
Then, my lord, but that point, my lord, because
All
we
right,
don't.
you argue that point.
Yes.
If it is not applicable, I will ignore it.
Yes.
That is no issue.
Yes.
Come to the second
So
point.
that's the first point. That will also explain the delay. There's a delay, my lord, of several decades. And second is, my lord, then since it has been got in common form, we have said we have taken a lot of points of what are the suspicious circumstances. When it is done because our contention is that the consent affidavit we did not know about the consent affidavit. We have denied that we have consciously signed it. They have produced a document that we had signed it in 1987, or 80s. So the other points are the suspicious circumstances, which we are pointing out. One is that there are 2 attesting witnesses. Neither of them have given an affidavit. The advocate who had signed below the 3 attesting witnesses, by posing to be an attesting witness, as it were, he has given an affidavit. So the advocate of the testator, who is now the advocate of his wife, who is the propounder, my lord, the same advocate, he has signed and he has given evidence that he was the attesting witness. There is no mention about who are the other 2 persons who apparently seem to be a neighbor and the other person we do not know. So that will be the second point, that it is a suspicious circumstance that the 2 attesting witnesses did not sign. So I have to show my lord those, there are some cases also. Next is, well, our contention is this could have been a draft at best. So on a flimsy piece of paper, it's just a typewritten document and there are signatures at the bottom. And our case is that he had...
Did you file any consent?
They have shown that we have filed. We have denied it in our reply. We have filed a consent. We have even accepted some money after the death. Some receipts they have given. But the contention of our client is that these were on blank papers. On trust, she had done it. It's the mother who's the propounder. And the daughter was living in Bombay, other places, and now she lives in Delhi. They are quite aged, all of them. But in any event, the dispute is that the next point, the third point is, if my lord sees the affidavit of assets, says the properties except for one immovable property is nil, cash in bank nil. And the client, the petitioner, my lord, knows for a fact that her father used to work as an executive in Tata. So, my lord, it is impossible that he had no money. So it's all nil. The fixed deposits, securities, etc., bank accounts is all nil, has been shown. That is why we were insisting that the inventory be shown, because he has passed away in 1987, and the wife
was granted.
87, that year itself.
When have you filed it?
We have filed in 2019 or when we filed 19.
So what about limitation? What about limitation?
Yes. So if the inventory hasn't been filed, then the petition is still pending in that sense. So that would save my limitation. And I have, of course, said that we came to know after we filed the partition suit. The petitioner filed the partition suit in 2018. I'll take my lord through the petition. 2018, we filed the partition suit. They took out an application for dismissal of the suit on the ground that probate had been granted in 87. Then we made searches and we found these records. And thereafter, when we filed this application. So saying So, my lord, the third point that I was making of suspicious circumstance is that the assets have been shown as nil. Despite that, we have been paid a certain amount of money. I admit that we have received the money. I don't admit that the signature on the receipt was given with my knowledge, as it were. The contention is blank papers were signed. Be that as it may, my lord, and I get 50 under this will, even if it is probate is done, I get 15% of the immovable property, movable properties, and there are nil movable properties. So that is one of the suspicious circumstances as well. And the last suspicious circumstance, I've told my lord about the attesting witness, the quality of the paper, and
What about your knowledge? When have you stated? Where have you
yes,
stated?
we have stated in our affidavit.
In application?
In the application, my lord, we have stated in paragraph 4. I think. Yes. If my lord comes to paragraph 7.
Paragraph 19, I think.
7 also, first initially. In June 18, the respondents filed an application for rejection of plaint of the suit, and for the first time disclosed that he had alleged Mr. Late Shubi Sen had allegedly executed a will.
That is in June 18, you for the first time came to know of it.
Then we made searches, and then we have said we came to know of the existence of these documents, and then we
applicant came to know of the existing will only on about 14/9/2008.
Now this in the affidavit in opposition, they have shown that my client has signed the affidavit of our consent in the beginning, and also signed.
Were you minor at that time?
No, we were not minor. So we have given in our affidavit in reply, we have said that these blank papers must have been taken from me, and I was not aware of this. So that is the thing. But these, my lord, this will all hinge on the fact whether the inventory was given or not. Because till such time, that's why I've made a GA in the pending proceedings. So till that time, my limitation will be saved because there's no real time limit. I'll show my lord 317, section 317. Yes. An executor or administrator shall, within 6 months of the grant of probate or letters of administration, or within such time as the court which granted the probate may appoint, exhibit in the court an inventory of the full and true estimate of the property in possession, and all credits and all the debts owing by any person to the executor or to which the executor or administrator is entitled in character, and shall in like manner within a year from the grant or within such time as the court may appoint, exhibit an account of the estate. So these two things are to be given: an inventory of what are the assets and what is the account. But this we have contended in paragraph 25 of our petition. We have said that we could not find these, and now the records are here.
Last order,
Your lordship's last order was that the records be shown. So if my lord sees if there is an inventory and accounts, these are the two things.
All right. So your point of argument is that first, so far as limitation is concerned, since inventory has not yet been filed, so
Yes.
it is pending matter.
Yes. Now then
filed.
2 is that suspicious circumstances is
First is on limitation.
yes.
And it came to your knowledge on 14 September 2018.
Yes.
So that is one point. Second, will execution of will is attenuated with suspicious circumstances.
Yes. And since it has been given in common form, this opportunity was not given to anyone to bring these to your lordship's notice. And since it's a court of conscience, now your lordship will have to weigh whether limitation will prevail, or if these facts are brought before my lord, whether the court can still look into it, whether it can be a ground for condonation of the delay. If the suspicious circumstances cumulatively, if they have an effect. Now the suspicious so this 317 which I showed, if my lord, since your lordship is looking at the act 263, if my lord sees, it's a specific ground that is recognized, 263.
Willful. The word
The
willful.
grant of probate or letters of admission may be revoked or annulled for just cause. So it's for the cause of justice. Then explanation, just cause shall be deemed to exist where there are several grounds where the proceedings are deemed to be defective, where there's no citation given, etc. But my lord will come to the point E.
Willfully and without reasonable cause. That is most
The
important.
person to whom the grant has made has willfully and without reasonable cause omitted to exhibit an inventory or account in accordance with chapter 7, or has exhibited under the chapter an inventory or account which is untrue. Now, till they have done this, if they have not filed it, then this is my application for revocation will lie till the time he doesn't file. That is my contention for limitation as well, and it would be a ground. Now, if factually it is found that he has filed, then my lord, we did not know even till today whether he has filed or not, because inspection has been taken by our advocates. And so this point, my lord, is the main point. If I succeed on it, it can be revoked. And if I don't succeed, then at least my knowledge of the inventory will happen, because my learned friends are reluctant to say. If he says it, I've been arguing this for 2 days, and your lordship has given us opportunity to do this.
You do one thing, you file a small notes of argument.
Yes, note I'll file, and I want to place 2 or 3 judgments on suspicious circumstances. I'll give them.
Are you ready for hearing today?
Yes, my lord.
So you start your argument. What is your answer?
No, my lord, I've got these. I have to show these
Finish it.
cases.
Why you are delaying? Finish
No,
it.
if your lordship ask me to make a note of it, I have got my note. It's a bit long because I have set out the judgments in my note. I can give that to my lord. I can prepare it a little better and give it to my lord.
So next day you file your notes of argument
Yes.
along with all
I'll
your
share it with my lord. In fact.
Sab, in the meantime, before the
But will your lordship take note that the records are here, and if the inventory is there?
Call for, let me call
No,
for a report.
your lordship has called for it in the last.
Not the report, whether that is filed or not. That may be misplaced. That may not be in
Yes,
the record.
that's why I'm diffident to make this argument in full. Then let the report come, and then I'll
Under section
317. Whether inventory or whether
Let my
accounts.
learned friend finish his argument, my lord. Today is the 3rd day. This is being reopened after 30 years. My clients are suffering, my lord, unnecessary.
This is the 3rd day I've asked for it,
filed or
the
not?
inspection.
Under section 317, the register of insolvency shall submit a report on the next date. With a report under section 317 is filed inventory.
Inventory and accounts. Inventory
And
within
accounts.
6 months and accounts within 1 year.
Has been filed in this case. Report shall come in this court on 29th August.
Because my whole argument will hinge on this one. I don't
Let
want
that
to.
come.
Yes.
You check whether what report comes. You file your notes of argument along with all your judgments.
Yes. 29th.
29th is 2 weeks time. That is enough for the register of insolvency to submit report.
Great.
Is it necessary?
Let them come. Let that come. I have to know also.
Because, my lord, I would be submitting it's a mutually destructive plea.
Let you argue.
Once you ask for accounts, you are admitting the will, and then you are saying that distribution has not been made in terms of the will.
No, it's for saving limitation.
You argue that.
Item 18.
My lord, this is the,
Yes. Where is Mr. Shah?
my lord, he is on his legs. My lord, he shall be joining soon. My lord, they have finished their submissions. My lord, we shall take hardly 10 to 15 minutes, my lord, and we shall complete our reply to them.
We have completed submissions as far as GA11 is concerned.
My lord, I shall be also restricting myself to GA11. My lord, just to briefly.
Today is GA11.
My lord, they have concluded their submissions on GA11, my lord. We are on reply. My lord, just to briefly recapitulate, my lord. My lord, in this, my lord, we are the plaintiff.
Mr.
my lord.
Bush point is that it is admission of yourself. Your witnesses stated that it will be 10 on
10 to 15.
10 to 15. That was in the year in respect of the year 2005 or something.
5-7.
So it should be 5. And so in that case, you will be liable to refund something, even if it is 10. That is the argument of Mr.
My lord, with your lordship's kind leave, my
Am
lord.
I right?
Yes, my lord, I have prepared the note. There is actually no admission. It is the statement of the
Yes,
plaintiff's
that's I
witness.
reiterate.
Yes, and even if you take the plaintiff's
If
witness,
that plea, according to you, if that plea is accepted, figure will come down to 5 rupees 5 per square feet.
no, my lord. Yes, my lord.
According to their admission.
You are absolutely correct. My lord, if you take the admission of the plaintiff, the on back calculation, it has been mentioned, it comes to about 5 rupees per square feet. One.
So they are liable to refund something.
Yes.
That is your point.
Yes, sir, this is one. And my lord, some cases were there which were not shown by Mr. Although we had planned it. I can give you whatever.
Give a copy. Give copies.
Yes, yes, I've given copy to them. Your lordship does not, because I said whatever I'm arguing, it's all there.
Yes.
So I've jotted it down. It will come back to your memory. But formally, may I hand over the copies of the cases?
Yes.
Yes. And then written notes. Yes, yes. My lord, may I hand it over? Yes. And I've also
Be annexed all these cases.
Yes, yes. No, not with this note, but separately I'm giving it.
And just give a staple. Just
Now, Uttam Singh Dugal was given. There were 2 more cases.
Staple with it.
Yes. Staple kore de. Staple kore.
Staple
And
does
they had cited one case. I have distinguished it in my note.
Stapler.
Shall we do it with the note?
বলছে তাই একটা বড় স্টেপলার দিন বড় স্টেপলার দিয়ে আটকে দিই My lord, I'm not formally citing all these cases. The proposition of law which I've said, I mentioned with the paragraph numbers. You will see it. And I've also distinguished their case where they said, my lord, what implied admission can be done by citing a case. My lord, does not apply in this case.
My lord, very, very short submission. My lord, my learned friends, if your lordship sees the note, my lord, which we have been favored with this morning, I would have appreciated had it been given, my lord, at least a day earlier. My lord, the main crux, my lord, of the submission of my learned friend is twofold. The first submission that is makes is, my lord, at page 2 of the note. But if your lordship will kindly see that. He says, my lord, Roman 4, IOCL states that the alleged admission is not an admission by IOCL at all.
এ কোথায় বড় স্টেপলারটা দিয়ে আটকাও না ওইটা কি করেছো
May I take it?
You kindly come to page 2 of my learned friend's note.
Page 2, which one?
Well, at Roman 4, the alleged admission is not an admission at all. Let me just read the first few lines. IOCL states that the alleged admission is not an admission by IOCL at all. In fact, the statement extracted in paragraph Roman 2 above was a typographical error, and the same should have been the plaintiff with all documentary evidence and with established procedure method of calculating the rent proved that the ground rent occupational charges of subject premises can at best be 10 to 15 per square feet. So instead of defendant, he wants to read this as plaintiff. Now, my lord, we are familiar with, my lord, the fundamental rules of pleadings. My lord, my lord, filed an application, my lord, that is GA11, relying on this admission. Well, I would have expected my learned friends to then say, my lord, in the affidavit in opposition that was filed to the application, that this is a typographical error. Not said. Well, today, can my learned friend for the first time, my lord, attempt in his desperation to argue that this is a typographical error? My lord, we are all familiar with the concept that, my lord, what is not pleaded cannot be proved. My lord, you cannot, my lord, depart from your pleadings. You are shackled to your pleadings. If you have not taken this point in affidavit that this is a typographical error, this is in fact, my lord, something that the plaintiff has stated and not the defendant, you cannot, my lord, advance that argument here. On the contrary, my lord, very, very important, what my learned friend says in their affidavit in opposition, that this is an inferential admission. My lord, that paragraph, my lord, we have shown to your lordship. They say this is an inferential admission. Now, my lord, is an inferential admission a good enough admission to fasten liability? The Supreme Court says yes. The Supreme Court has said an inferential admission is as good as an admission itself. If you can infer, my lord, even from conduct that he admits to a state of affairs, then, my lord, that is a good enough admission. Now, my lord, my learned friends have, my lord, relied on, my lord, host of judgments, Uttam Singh Dugal and others, my lord, where they've tried to say admission must be, my lord, unequivocal, unqualified, this, that, and the other. But, my lord, when we rely on the judgment saying that an inferential admission is a good enough admission, and, my lord, liability can be fastened on person on the basis of such admission, let's see, my lord, my learned friend just said he has distinguished the judgment. Well, let us see how he has distinguished it. Well, kindly come to page 5 of the note. Well, kindly see Roman 10. Judgment relied upon by the plaintiff Sudera. Charanjit Lal Mehra versus Kamal Saroj Mahajan, 2005-11 SCC, para 8. He only says this judgment of the Honorable Supreme Court is wholly inapplicable since the present case there's a prima facie error, typographical error, and dispute regarding the statement by IOCL, which is not at all admission. So, my lord, his distinction of, my lord, the case, my lord, which says Supreme Court says inferential admission is good enough, is on the basis that the statement is a typographical error. My lord, where is it stated in his affidavit? Can we, my lord, from the bar make this statement for the first time? Well, I ask myself this simple question. Now, my lord, here, my learned friends have then, my lord, gone on to say, my lord, that this was what before the special referee and that was before the special referee. I can take your lordship through all of that. But, my lord, what the special referee ultimately, my lord, concludes is that the rent should be 60 rupees. Now, my lord, the special referee also relies on a report of Talbot Company, my lord, that is there on record, which was later affirmed by the Supreme Court in respect of the same building at 45 rupees per square foot. And that is in 2019, not very long back. Now, my lord, I can go through all of that. The simple question before lordship is, my lord, today, my lord, GA11 only proceeds on an admission. My lord, that admission my learned friend accepts as an admission unless he can satisfy a lordship.
GA9 is for?
My lord, GA9 is, my lord, for the decree on the basis of the special referee's report.
Okay.
My lord, GA10 is, my lord, the exception to the report. GA11 is, my lord, saying that very well, till the court decides, my lord, GA9 and GA10, GA11 proceeds on an admission that they've made in their opposition file to GA9. In the opposition file to GA9, they say,
GA11 we are concerned with.
yes, that's right. That is what your lordship is hearing. Now, my lord, my lord, only proceed on, my lord, a simple admission. My lord, we have given your lordship the calculation. We have said what is the money that we are entitled to at 15 rupees per square feet. My lord, we have said we are also entitled to, my lord, interest that the special referee is awarded at 9%. We have said, my lord, it is inherent in an adjudication of, my lord, mean profits that, my lord, interest is allowed. They have not questioned that part of the special referee's report saying that, my lord, interest should be allowed. They only challenge the quantification. Now, my lord, quantification your lordship will certainly decide. And, my lord, now, my lord, the law is quite well settled by our court and by the Supreme Court, which says, my lord, unless you find something glaringly wrong with a special referee's report, you do not normally interfere with it.
Basically, we are concerned with whether we shall, I have ordered this refund of or payment of at the ad hoc payment of rupee at rate rupees 10 per square feet.
15, my lord.
15 per square feet.
Yes.
On the basis of admission.
That's right.
Thereafter, we'll consider whether it is 15 or something more should be given or
That's right. That's right. Of course. Now, my lord,
so
here,
for the timing, let us consider whether this order can be passed.
That's
10
right.
or 15, whatever that.
now, my
time.
lord, today, my lord, this order, my lord, today, there are two things that are, my lord, now established. A, that they were in wrongful occupation. That, my lord, they cannot challenge anymore. That was the main contention that advanced before
Where
this
is the
honorable
appellate
court.
court order?
My lord, your lordship wants the Supreme Court order, my lord?
Appellate court order.
Appellate.
Appellate court
Yes,
pass
yes.
order.
Yes, 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 my lord. Yes. Well, that's the order of 22nd February 2023. Does your lordship have a copy, my lord?
Okay. So whether it will be 31, 34, 46, 60 is not a matter of concern right now.
Right now.
That we'll consider.
Right. Now, my lord, when I file, my lord, first thing, my lord, admittedly, wrongful possession. Well, the period of wrongful possession was in question. That has been all decided. So, my lord, we now know that they're in wrongful possession and wrongful possession from period A to period B.
Everything is settled. Even Supreme Court
That's
said it will be from the date of unauthorized occupation.
So, my lord, they have to pay, my lord, mean profits for this period. The question is at what rate? Well, a special referee has decided a particular rate at 60 rupees per square feet. They have challenged that rate. I have asked for a decree on the special referee's report. They have, my lord, questioned that. So, my lord, whether your lordship will pass a decree at 60 rupees or not, your lordship will consider.
That is a subsequent matter.
That's right. And now, my lord, here, my lord, in their opposition, they say, they make this statement, which we rely on as an admission. They're saying it could at best be 10 to 15. Now, if it's 10 to 15, well, in a prime area, my lord, this is the SE market building. Lordship knows. In a prime area, 10 to 15 rupees, my lord, then, my lord, one has to naturally take the higher side. Because, my lord, when you say 10 or 15, my lord, naturally 15 is what you accept as also payable. And you accept that, my lord, with the interest that, my lord, the special referee is directed. So, my lord, I have calculated that. Now, my lord, my learned friend's primary defense, only two. A, it is a typographical error, it's not an admission. He cannot take that point. Because, my lord, he's shackled to his pleadings. Unless he has said it's a typographical error, he cannot now invent, my lord, the typographical error in the course of his arguments from the bar. That's number one. Number two, my lord, if today he has to, my lord, say that this is not an admission, he has to get around the, my lord, Supreme Court judgment which says an inferential admission is an admission. Now, my lord, why do I say inferential admission? Because he has in his affidavit in opposition said that this is an inferential admission. And, my lord, that an inferential admission is good enough is what the Supreme Court has held. And he attempts to distinguish the Supreme Court judgment merely by saying that no, this judgment does not apply because there's an error. What is the error? It's a typographical error. It's not an admission by the plaintiff, it's an admission by the defendant. Not an admission by the defendant, admission by the plaintiff. But if that is not available to him, he cannot, my lord, travel outside, my lord, the scope of this admission. Then, my lord, the next point that he seeks to raise, my lord, on the basis of judgments, is judgment must be clear, must be express, must be unambiguous. Well, lord, today when we talk about an inferential judgment, is your lordship looking at, my lord, clear, express, unambiguous? What is the object of the court? The object of the court that is that the party who should not be put to unending suffering. And, well, if it can be inferred, well, lord, from the conduct or from the statement of a party that, my lord, yes, he admits to a particular position, then that is something that should be given. Now, my lord, here, my lord, so far as this is concerned, my lord, kindly bear in mind that the suit was filed in 1995. And, my lord, the issue in the suit was, my lord, wrongful occupation and mean profits. My lord, today we are in 2023. My learned friend says that they have made payment. My lord, they have made payment at the contractual rate of rent. My lord, which we have adjusted. Now, my lord, comes the question of adjustment. So far as the question of adjustment is concerned, we have said that, my lord, in our affidavit, my lord, we have already filed that we have said that this is the amount that you have paid towards rent, which we have given you credit for. This is the amount that you have paid for electricity charges on actuals, maintenance charges on actuals, because you were in occupation of the property. That cannot be a part of the rent or occupation charges. So, my lord, that is something on actuals which you have paid, I have paid, passed it on. I have not received it. My lord, that is given. And, my lord, that those documents on record, my lord, we have already enclosed with our affidavit, showing that, my lord, this is on actuals, bills raised, payment made. So, my lord, the question now, if your lordship sees, my lord, the notice, what is the defense? The defense is twofold. Typographical error. So, I'm exonerated. And two is that admission has to be, my lord, unambiguous, clear. Well, this is clear. What can be clearer than this? Now, my lord, if your lordship wants me to take back, my lord, to what the arguments were advanced before the special referee, the report is on record. But, my lord, I do not think at this juncture, my lord, we need to trouble your lordship. It is a very simple application, proceeds on a very simple premise. And the premise is that you have admitted that, yes, you have to pay occupation charges. It can be between 10 to 15 rupees. Now, my lord, if that admission is there and they have said in their affidavit it's an inferential admission, my lord, there has to be a direction for that payment. My learned friend's primary defense, typographical error, not available to him. His, my lord, defense that, my lord, unambiguous, my lord, clear, etc. This is, my lord, clear as daylight. You have said, yes, I have to pay between 10 to 15 rupees. You have said that, yes, this is an inferential admission. Now, my lord, today on that basis, my lord, an order has to be made. Now, my lord, so far as an inferential admission is concerned, the judgment on which I have placed reliance, which my learned friends have sought to distinguish only on the premise that it's an error. my lord, is, my lord, something that, my lord, he cannot escape, because, my lord, he accepts the fact that, my lord, this is an inferential admission, and my learned friend Mr. Bose's, my lord, argument from the bar cannot change that. In fact, I was a little surprised that, my lord, he should depart from his pleadings and, my lord, make this argument which is not a part of his pleadings. My lord, we never do that. But I was not only surprised, I must say I was a little shocked, because, my lord, we have, my lord, grown up with the notion that, my lord, you ultimately are shackled to your pleadings, you cannot escape your pleadings. So if I have not taken the point in my pleading that this is, my lord, a typographical error and hence does not constitute an admission, and that it is an inferential admission, then, my lord, how could my learned friend from the bar, my lord, make the statement that it's a typographical error? And, my lord, he proceeds on the basis of, my lord, reliance on the special referee's report, and this is what was said, and that was, I can take your lordship through the report, I can show your lordship that the Supreme Court has accepted that in respect of the same building, 45 rupees, my lord, is, in fact, my lord, there was an adjudication of mean profits at, my lord, 75 rupees. Supreme Court there said, very well, Talbot and Company has assessed it 45 rupees, take 45 rupees. Well, that is, my lord, what my learned friend is now contending against. So, my lord, Supreme Court has accepted, and it's on record that, my lord, 45 rupees you pay. It was 90 rupees. Supreme Court, my lord, said that very well, since there is a report. It was kind of a compromise that Supreme Court, my lord, arrived at. But in respect of another flat in the same building. Now, my lord, today, how can my learned friend come up with this kind of a case? Well, I will not trouble your lordship, my lord, more. I am in reply. My lord, all the affidavits have been shown, admission have been shown, cases have been shown. My lord, what I will do, my lord, because I've been favored with this, my lord, note this morning, I will request your lordship, my lord, for some. I have a note ready. But, my lord, I have not been able to deal with, my lord, these aspects which my learned friend now, my lord, makes, my lord, the basis of his argument before your lordship. So, my lord, if your lordship permits me, I shall, my lord, put in a note, my lord, within the next 3 or 4 days.
Well, only one submission. Since my learned friend was quite harsh on Mr. Bose, that you should be
Not on you.
shackled to your pleadings. No, he mentioned Mr. Bose also to me.
Not you.
I have counted 7, my juniors counted 10. My learned friend has said that we have said in our affidavit, it is an inferential admission. 10 times he has said it. And please let him show that.
Well,
That is the thing. That's only thing.
Let me show
Because
it.
I am reading the affidavit.
No, my lord, let me show it to your lordship.
Then I'll be.
Let me show it, my lord.
In this affidavit, in 11. Yes. Let him show it. And what is the error that we are saying? Let your lordship will see, read our notes and see what is the error. Their witness before the special referee said 10 to 12.
I can go into
He
the
has
special
quoted.
referee's report.
Yes, he should go in.
No, my lord.
Just saying,
question
it's a new point.
Course, we are now concerned in specifically in GA.
In this, first of all, it's not an application for judgment on admission. First of all, that anyway, that they've argued. Where's the word
Let
inferential?
the argument be
Then
finished.
I'll
Let the notes of
Well,
argument come.
My lord,
If
paragraph
necessary,
7.
I will hear you
Page
reply.
Page 7, paragraph, my lord, 7.
Can I stand for it?
And, my lord, then it says the statement referred. Well, I shall read out.
Yes.
Which one?
My lord, the affidavit in opposition filed by my learned friend to
Where
the
is the-
section 11 application,
Page
GA 11.
Inferential, sir. No, only thing is, I stand for it.
Kindly see page 7, my lord. Paragraph 7, last 5 lines.
Inferential admission, yes.
The statement referred by the plaintiff can merely be considered as an inferential admission or a subjective or one-sided statement to the calculation averred by the during the special referee proceeding,
in which
upon which the honorable court should not deduce an admission as a result of interpretative exercise. My lord, so, my lord, today when I say, my lord, inferential admission, my lord, I will not make this statement unless I'm sure about it.
They've given me this wrong here. This is the here to the supplementary.
No, I'm sure that my
Yes.
learned friend has not consciously
Writing
made
that.
this statement. But, my lord, this is, my lord, where we stand. My lord, I shall, my lord, with your lordship's leave, put in a note, my lord, within the next 3 or 4 days. I have a note ready, but, my lord, I need to deal with, my lord, these aspects of the case.
Or Mr. Shah, the learned counsel for here for
Well, I appear for the plaintiff.
plaintiff GA number 11. The order করো adjourn to
So that's
1st September.
1st September. But in the meantime, is it your lordship's pleasure that we file the written notes with your lordship's officer, or my lord, we file it before court?
Before court, because I will not be here.
That's very. My lord, GA11, my lord, hearing is concluded, my lord.
No, you file notes of argument for GA11.
Very, very.
Come, let's do information admission together. Sudhir Asher. Oh, you know.
Who is for the plaintiff?
I'm for the plaintiff.
For the plaintiff number 2, your lordship.
Who is defendant?
Plaintiff number 1, that the title.
I appear for the defendants. I'm being led by
Judge.
no papers in this matter.
No. But the last time we had appeared, your lordship had called for the report.
Judge's brief of document has not yet been received.
Correct. Now we've been favored with a copy by the defendants. It
Parties
appears.
discover and inspect the documents in the meantime.
No, but we've just been favored with a copy of the judge's brief of documents. By your client. No, that's right, but it was with them. Because there's a change of advocates, we did not have anything. Your lordship called for the records. It appears that this was not, JBOD was never filed. Then the defendants came and submitted on the last occasion that they have a copy of the JBOD. So your lordship told them to give a copy. So on my cost, and they've given us a copy. It appears that out of 100 odd documents, 27 are ours, and the remaining all are of the defendants. But inspection, I don't think has been carried out. Admission denial has not happened.
Yes.
So if that exercise can be conducted in the meantime, Mr. Ghosh will just consider.
It's been made by them.
I think the Dina.
It must have been. My learned friend can say that they're new. How could the judge's brief is made by the plaintiff?
Could
We
be,
have a copy.
but
Because order
admission
was
denial.
not to file judge's brief of document. Order was let the parties discover and inspect the documents on the return within the returnable date.
Correct. So now that
It's not done.
that has not been done, even if it
So I've
was
given
done,
you time to do that.
to let us have inspect the originals and we'll prepare the admission denial in the meantime and come back. But Mr. Ghosh will just consider if how things are today and considering this absolute lack of clarity apropos the documents, if the matter can be argued on the basis of what is there and on the probative value of the documents without any evidence being laid. If he is okay with that, because it will come down to a question of law, Milord.
Plaintiff's choice. He has the carriage of proceedings. If he doesn't want to give evidence.
No. Then if I don't give evidence and he decides that he will lead evidence, then I'll have to lead evidence.
That's
Whether
separate
primary,
issue.
second.
But first thing is that whether you would conduct discover and
No,
inspect
that I'll conduct.
That
The
we are
discovery
confined with
inspection and
this
admission
also
denial, let
like-
us conduct.
that is to be done and we are confined with that part only.
Yes, and even if we don't lead evidence after admission
That
denial,
will
on
be
the
taken up
probative
later.
value, we can argue.
That will make up a later case. That
Issues have been framed.
with issues are framed without all these things.
Yes.
My lord, inspection and it's a 2000.
2000.
But all these things were done. Otherwise, judge's brief, he's the plaintiff. He has taken inspection. I've given him photocopies of my documents. He's prepared the judge's brief.
Can you show me the order sheets?
That I would have to see. So the judge's brief is there. I've shared it with the learned friend. It's there.
So you do one thing, you come up with the olden orders.
Well, that will also be wasting your lordship's time. Let us just proceed. 23 years we've wasted, my lord. Let us just go ahead and take inspection of whatever documents they have.
If they want to take an inspection again,
Correct.
of course, we'll have to see what we have now. They have prepared it.
Discovery and inspection of documents.
But discovery is done. The judge's brief
Just
has been
inspection.
shared.
Discovery,
Inspection,
no
the
further.
learned counsel for the,
Inspection.
you are for defendant. You are for defendant.
I'm for the plaintiff.
Learned
Plaintiff
counsel
number
for
one.
the plaintiff submitted that inspections are yet to be done.
Prepared by the plaintiff.
So he
come on.
put my
The inspection of documents shall be complete within the returnable date. The matter will appear in the suit will appear in the list on 20th September.
Admission denial in the meantime. Lordship has directed admission denial in the meantime.
Admission and denial may be made in the meantime. Let these things be done
Yes.
and be complete.
Yes.
demonstrated.
What GA6 is about? GA6?
আমাদের gives me a minute. একটু তাড়াতাড়ি করো। Irrelevant, it was just to expedite the suit.
What is about it? This shows
For
getting.
expeditious disposal of the suit.
Come
that
on
can
the
be
next date, I
disposed
will
of.
pass order on this.
On the next.
For orders, item number 20.
Substitutions are to be made.
Substitution application
Have you filed it?
Yes, my lord, I have filed the substitution petition.
That may be allowed, my lord.
And master sounds already.
Maybe allowed, allowed here and now.
Where is the application?
GA19.
GA19.
Maybe allowed. I cannot oppose to that.
Your defendant number?
2, my lord.
I appear for defendant number 3 and 4, my lord.
Have you any objection regarding this one? Any defendant has any objection?
No, we don't have any objection. No defendant can have any objection. And this is
GA 19 of 23 is filed. Master summons. With prayer for substitution of defendant number 3 by legal heirs and successors as mentioned in what the legal heirs and successors?
Yes, my lord.
Para 7
Yes, my lord.
as mentioned in para 7. The learned counsel for the defendant did not object to. Right to sue survive since this is a partition suit. Let defendant let prayer A be allowed. A of the master summons be allowed. Where are your other prayers?
Yes, my lord. I wanted to substitute that and
That changes may be lost in where is your substitute that have changed? May be made in the cause title. You do one thing, you withdraw this application, file it afresh. With all this press, because planes are to be, cause title are to be changed. All these things are to be done.
So after passing orders, you will also, as per original side, thereafter the department shall carry
There is
out
no
the-
prayer. Normally there are prayers. Set of prayers.
Yeah.
Nothing is there, only show cause.
No, my lord. There is a case.
Only substitution is there.
Yes, my lord.
Not in the master summons, my lord, but in the application.
Only showing cause.
Yes, my lord.
Then may leave be granted to
Withdraw it and file it afresh. Issuing rule asking them to show cause. There must be a specific prayer that they may be substituted. Their names may be inserted in the cause title.
My lord, para 9 I have already stated.
Where is that in the master summon? Where is that prayer?
Yes, not in the master.
leave be granted to amend the
Instead of amending, you withdraw it. Just withdraw it and file it afresh. That would be better. Leave is granted. Leave is granted to withdraw the application, namely GA number 19 of 23 because of technical reasons, and file it afresh. GA 19 of 23 accordingly stands disposed of.
GA 18 is my injunction application. It has
Let that be a let substitution be made first.
that is there, my lord, but
At the end of the suit, you are asking for injunction. I will consider that whether should be allowed or not, but let the substitution be done. The matter will appear in the list on 29th August. First, 31st August, not 29th, 31st August.
31st August. Yes, ma'am.
Old suits. Item number 30.
But in this matter, I'm appearing for the plaintiffs. But the parties are trying to settle the matter. An order was passed, my lord, in 2021, directing the defendant number 3, United Bank of India, to indicate whether they had any claim in the suit. Now, my lord, after that, my lord, United Bank of India became Punjab National Bank. We have caused substitution. Now everything is all right. My lord, similar direction be passed. Instead of United Bank of India, let it be Punjab National Bank, my lord. At that point of time, my lord, substitution was not done. That's why, my lord, the order stated, my lord, last paragraph of that order of 22nd April 2021. The advocate on record of the plaintiff is
I will
direct.
not pass this order, you settle yourself because this is not court settlement through court. It is amicable settlement.
No, but my lord, if we comply with the order now and we address the letter to United Bank of India, they will not respond. We don't want anything to be left out. If they have any claim, my lord, we will clear it off. But they have to come in.
That you explore yourself.
Yeah, but we have done that, my lord. There is already an order. After that, my lord, United Bank of India has become Punjab National Bank. I am praying for the same direction, my lord, instead of upon United Bank of India, Punjab National. My lord, if there is an order of court, my lord, they will come. If they don't come, then none, the rest of the parties will settle, my lord.
Court cannot force anyone to come.
No,
to a settlement.
absolutely not. But only to indicate, my lord, there is already a direction to file affidavit on.
Order was passed on 22nd April 21 by this court.
এটা কি কমিউনিকেট করেছিলিস?
Communicate করা হয়েছিল।
Noting the possibility of settlement by the parties out of court. The parties shall inform this court whether there is any settlement took place as noted in the order dated 22nd April 21. Copy of this order may be sent to
My lord,
the parties.
my lord, may I just indicate, my lord, I am appearing for defendant number 4. My lord, I was the one who was contesting the suit. Talks of settlements are going on, my lord. Only difficulty is, my lord, if Punjab National Bank comes up and says that I have so much of claim, my lord, we as my learned friend submitted that he's
Like,
willing
let
to
the
clear.
copy of this order be sent to the substituted party.
Yes.
That's why I'm passing order.
Yes.
This sent to all the parties.
Yes.
You will them? To all the parties by the learned counsel for the plaintiff, along with this order. Let the matter appear in the list on 25th September.
I am grateful to you. তাহলে এই অর্ডারটা এনক্লোজ করে এই অর্ডারটার সাথে আর ওই চিঠিতেই বলে দেবো আপনাদের কোনো ক্লেম থাকলে
31 adjourned. Who is the other side?
I appear for the response.
He is seeking for an adjournment.
My lord,
No,
let,
my lord.
directions for affidavit be made.
But
My lord,
only
this
thing
is-
I want to, my lord, I asked through myself, my lord. This is a matter, my lord. I find today, my lord, that matter is GA number 15 of 2023 is in the last GA in this matter. Now, my lord, I do not know, my lord, this is a matter where, my lord, the plaintiff number wants name to be deleted because she has already assigned her interest and the plaintiff number 2 is here. Now, my lord,
You
only.
are plaintiff number?
Defendant number 2.
Lord,
My
what
lord,
is-
my
what is-
clients are,
You are?
I am plaintiff. Now, my lord,
What do you have to do?
my lord, my clients are from Bombay. My lord, I have to take some instructions because this is a 2000.
That's why adjournment is.
My lord,
Let there be
my lord,
adjourned.
let there be an affidavit, direction for affidavits
what is the
also.
purpose, my lord, the affidavit of GA number?
The learned
15?
counsel for the
affidavits?
defendant submits that he needs instruction from his client,
Defendant number 2, my lord. Right?
defendant number 2, and intends to file affidavit in opposition against GA number 15 of 23. Let affidavit in opposition be filed within 2 weeks and reply if any within 1 week thereafter. The matter
Provided
will-
the copy be given to me early. my lord.
Yes, the matter will appear in the list on 14 September. GA 15.
But instead of 14, my lord, could it be in 13th or anything, but
15 September.
yes, my lord. Grateful.
Item 32. Lord, item 32 and 33, I appear for the plaintiff. Lordship will kindly keep this matter next week because the
Next week
substitution,
I will not be here.
well, then the week after, whenever Lordship comes
I
to,
will not
because
be here for 2 weeks. I'm going to circuit.
well, the earliest convenient date, because my substitution application is being filed today. Well, the defendant has been merged with another company.
Defendant means?
The defendant, HON'BLE Printing Company Limited, has been merged with Andrew Yule and Company. That has been notified by the defendant to the plaintiff. We have taken out an application that will be filed today.
On prayer of the learned counsel for the plaintiff.
Plaintiff.
The matter is adjourned to 19 September.
19th
Third-
September.
third-
Your Lordship, guide.
Mention it. Come it earlier,
Fine.
mention it, I will prepone.
Very well.
Because
Yes.
I cannot say, because some days are very congested, remains very congested.
I understand. But this will only be a substitution. After that, Lordship may keep the matter after, I mean, a few weeks.
8th September. Because otherwise my
Lordship is not there.
weeks are congested, my days are congested. I will be
understand.
here, not here for 2 weeks. So
I-
all this matter I have to accommodate.
I understand. Appreciate it.
Especially the arguments,
Those take time. These
Those take time.
substitutions, yes.
even today I have to sit at 3 p.m. in the division bench. I have
Ah.
so many witness action and arguments.
Grateful.
Item 21, Gurupada Mandal. And may I continue?
I am appearing on behalf of the plaintiff.
For the defendant, my Lord, I was asked. But on the last occasion, I had shown you the entire evidence relating of the plaintiff relating to the existence of the joint family. There are certain documents that I would like to draw your attention to. The first document that I would like to draw your attention to, the first two are exhibits 1 and 65 in this proceeding. Now, my Lord, exhibits 1 and 65 in this proceeding. Now, my Lord, instead of looking at the original exhibits, which are really in a haphazard state, kindly look at the additional judge's brief of documents which had been filed before this honorable court.
Page?
Page 689. It starts at page 689, Miller, because it continues from the original judge's brief, the pagination. Now, kindly come to page 691. 689 and 690 are the acknowledgement due cut, 691. Now, this is a letter. Kindly see page 693. This is a letter addressed by Sahadev Mandal, original defendant number 1, Mrityunjay Mandal, original plaintiff number 2, and Gurupada Mandal, original plaintiff number 1, to the requiring authority under the West Bengal Food Grains Procurement Levy Order 1975. Bamunpada Onchal, care of Block Development Officer P.O. Monteshwar, District Burdwan. Now, regarding objection against the levy roll on behalf of Sahadev Mandal, Mrityunjay Mandal, and Gurupada Mandal of Purbo Balarampur, such and such. Having learned that a levy roll has been hung up on the notice board of Onchal Office Bamunpada, showing therein the names of Sahadev Mandal, Mrityunjay Mandal, and Gurupada Mandal as one unit. The area of holding is 26 acres, and the quantity of levy paddy to be sellable under the West Bengal Food Grains Procurement Levy Order 1975 is 148.20 quintals. We, the undersigned, beg to file objection against the said roll on the following amongst other grounds.
Para
Now,
9 possibly you are referring to.
I am first referring to para 3. Para 2, para 3. Relation amongst us is brother. We are not member of the same family, even within the meaning of the West Bengal such and such. For that, each of us is separate person within the meaning of the said levy order, and each of us should be treated as separate producer. Then, my lord, 5, 6. I will not place the paragraph 5, 6, 9. So 5 and 6 relate to Mrityunjay and Sahadev Gurupada, and 9 is Vivekananda, where the three brothers are writing to a government authority saying, we are not only are we separate, even Vivekananda is separate from his father, Sahadev. And this document has been marked on admission of the plaintiff's witness, who has admitted to the execution and the submission of this letter. Now,
Exhibit
1. And kindly mark the date. At the bottom of page 693.
1975, 17th November.
4 years before the filing of the suit. So, contemporaneous with the time of filing of the suit, the plaintiffs who have run a case in the plain that they constituted a joint Hindu family with Sahadev are signatories to a document which they admitted in cross-examination issued by them, saying we are separate, we are not part of the same family. Now, my lord, the order was thereafter challenged by them in the High Court. The order on that challenge is at page 694 of the same compilation. It is marked Exhibit 65.
694.
Yes, just after the letter, my lord.
Exhibit
65. In the High Court, this is, my lord, your lordship will find the parties are at the end of page 694, and in the matter of Sahadev Mandal and others petitioner, so and so. But if I may straight away take your lordship to page 2 of internal page 2 of that order, These rules relate to the impugned levy orders passed under the West Bengal Food Grains Procurement Levy Orders 1973-74. After the promulgation of levy orders in 1974, a large number of petitions under Article 226 of the Constitution was filed and a large number of rules were issued by this court. It was mentioned before me by the Advocate General that because of these rules, an injunction passed by this court, food policy of government as alleged cannot be executed in full. Mr. Advocate General wanted that the copies of these page 2 of the order, my lord.
These rules relate to yes.
Yes, yes. May I please again? These rules relate to the impugned levy orders passed under the West Bengal Food Grains Procurement Levy Orders 1973-74. After the promulgation of levy orders in 1974, a large number of petitions under Article 226 of the Constitution was filed and a large number of rules were issued by this court. It was mentioned before me by the Advocate General that because of these rules and the injunction passed by this court, food policy of the government as alleged cannot be executed in full. Mr. Advocate General wanted that the copies of these applications may be served on the government pleader's office so that the government may take steps for vacating the interim orders passed by this court. I direct the petitioners that copies of these petitions may be served on the government pleader's office, and accordingly I was told by Mr. Sengupta afterwards that copies are being served on the government pleader's office. It was further agreed by the learned advocate on behalf of the petitioners and Bar Association and on behalf of the respondents by the Advocate General and Mr. P.K. Sengupta on behalf of the government that it will be very much convenient if these cases can be disposed of early. And it was also our concern that the huge number of writ applications filed against the impugned levy orders can be disposed of as soon as practicable. With that in view and with the cooperation of the bar and the respondents appearing before me, it was decided that the levy rules will come up in the list with numbers alone and the names of the parties will not be appearing in the list. Now, my lord, kindly skip over these portions. Come to page 4 at page 697 of the compilation. The paragraph at the end.
Yes, I have seen. In this application, the petitioner's allegation is that the petitioner Sahadev Mondal, Mrityunjay Mondal and Gurupada Mondal are three brothers and they have been served with levy notice of 100 quintals of paddy. The petitioners challenge that the petitioners along with other brothers have been tagged together, but the petitioner alone has only 8 acres and 3 decimals of land under the old levy order. Nothing is due from the petitioner. Though there is no affidavit filed by the respondent in this case, and it appears, however, that because of non-supply of paddy in accordance with the impugned order, the petitioner is being prosecuted by the respondents and FIR has been filed with Monteshwar PS. In my opinion, under the 1973 levy order, the family has been defined to mean husband, wife and their children living in joint mess or holding property jointly. Therefore, from the definition of the family as contained in 1973 levy orders, brothers above cannot form a family. Husband, wife and their children, adult or minor, living in joint mess and holding property jointly can, however, be included. In the present case, the allegation is that the brothers are living separately and cannot be included within the definition of family by the 1973 order. Now, kindly mark this. The allegation in the petition was that the brothers are living separately. As there is no affidavit filed by the respondent in this case, I am to accept the submission made by the petitioner in this case and direct that the levy roll, insofar as the petitioners are concerned, directing the petitioner to deposit 100 quintals of paddy may be quashed. It is judicially accepted.
Judicially accepted. Now, my lord, so this is completely destructive of their case of joint family. Thereafter, my lord, will kindly take 3 documents, exhibits 39, 40 and 41.
Page.
The principal judge's brief of documents may kindly be. I think the principal judge's brief has typed copies. What I have done is I have brought photocopies. My lordship will kindly look
Still,
at.
let me go through it first.
My lord, first kindly take page 348. But 348 is a license. My lord, your lordship will recall, I had said that there was no nucleus of a joint family. Sahadev had independent income of his own through which he purchased properties. The position was, accepted position is that in 1924, he came to Kolkata, started working in a firm where he became a working partner. But that business did not continue. Question is what he did thereafter. But the first document we had produced was Exhibit 41 at page 348, which was the license
41.
issued to Sahadev Mondal, 341.
Exhibit 41.
Exhibit 41.
348 is Exhibit 41.
Is Exhibit 41. Malad, the original license, I am just handing over, this is a typed copy. I'm just handing over a photocopy of these
So
documents.
let me mark here.
Yes,
Exhibit 41.
41. This is a license issued by the government of West Bengal under the Food Grains Control Order to Sahadev Mondal for providing him authority to purchase, sell, store for sale in wholesale quantities all or any of the undermentioned food grains. It is rice, and the place of business is 46 Nolini Set Road.
So he had his separate business or whatever that might be.
Yes. And it is not their case that this business of rice is not pleaded in the plaint to be forming part of any joint business or coming from any joint family. Next document is page 347. This is Millard.
Exhibit
40.
This is exhibit 40.
Yes. This is Millard, a license for carrying on business of oil seller issued by the Corporation of Calcutta to Sahadev Mondal.
It is not mentioned.
Millard, oil seller at the bottom.
Oil seller, yes, yes.
And the date, Millard, 30th January 47, and the earlier document was of 44. The exhibit 41 is of 1944. Thereafter, Your Lordship kindly sees exhibit 39, which is at page 343 of the judge's brief. This is a rent receipt, Millard, for the year 1956 in respect of premises number 46 Nolini Set Road.
Kalicharan Poddar was the superior landlord or owner, whatever that might be.
Yes. He was the landlord.
You want to show that if all these things indicate he had
independent business. The tenancy was his. He was
An
carrying on business from that
independent
premises, an independent entity. And therefore, this is important because in 1951, Sahadev purchases a property at 33 and 34 Mondal Street, which the plaintiffs say was purchased out of joint family funds. Now, my lord, your lordship will know that there are 6 or 7 tests which have been laid down by the Honorable Supreme Court for determining whether a transaction is benign. And the principal condition is the source of funds. And I will now take your lordship to the evidence and the documents with relation to premises number 33 and 34 Mondal Street. My lord, our case is that the Mondal Street property was purchased by us by way of a deed of conveyance. That deed of conveyance, my lord, has been marked as exhibit
page.
I'll tell you, lordship.
Page 333. This document is exhibit, marked as exhibit
333.
343. You just shown.
343 is exhibit 39. The deed of purchase is at page 635. It is exhibit 36. The original, I believe, has also been traced. Your lordship may even have a look at that. 635.
This indenture.
Yes.
No, this is 336.
635. It's a fold page, my lord, like this. Your lordship may kindly see the pages are folded. Your lordship will have to open it. 635. Defendant's document number 64, exhibit 36. Your lordship will see on the first page.
This indenture made on this 6th day of October.
Yes.
51 between Lal Torn up.
Lal Bihari Mollik, vendor, and Sahadev Mondal, purchaser. Now, Lal Bihari Mollik is the seller and purchaser is Sahadev Mondal. Your lordship has got that. If your lordship is not able to see from that, the original document, I believe, exhibit 36 page. Original document is available.
এটা নিয়ে নাও। It is also torn.
Yes, Milord, it could be. একটু exhibit 36 টা দিন না। But on the first page, your lordship will find the purchaser is Sahadev Mondal. Now, my lord, kindly take page 4 of that document, the memorandum of consideration.
$35,650.
Yes. Now,
346 pieces of notes, 100 each.
Yes, yes. So, my lord, this is the purchase deed. Now, the evidence is, and we have, this was our case in the written statement, and our evidence is that the money was arranged by way of a mortgage that was executed by Sahadev in favor of one Nandorani Dasi, who lent the money, a sum of rupees 20,000, to Sahadev for Sahadev to complete this purchase. That document is exhibit 3.
এটা রাখো।
Exhibit 3 টা একটু দিন। Your lordship will see the mortgage document also. Sahadev is the mortgagor and Nandorani is the mortgagee.
Wife of Lal Bihari Mullik.
Wife of Lal Bihari Mullik. She is the mortgagee. And the mortgage sum your lordship will also find is 20,000 rupees.
ওই ডকুমেন্টটা দেখে একটু। Same date.
Same date. Executed on the same day. Now, this money was repaid by Sahadev, which led to the execution of a deed of reconveyance. That is exhibit 2. Kindly, my lord, have a look at that. By this time, Nandorani had died.
One thing.
Yes.
In your notes of argument, you just refer these documents you are referring to.
Yes, I will. I will.
Exhibit number.
Yes, yes. Exhibit 2. Just for my satisfaction, may I show your lordship? Your lordship will see by this time, Nandorani had died. And Lal Bihari, as the executor of her estate, was executing the reconveyance, accepting the fact.
Lal Bihari is the son.
Lal Bihari is the husband.
Acha.
Husband. Lal Bihari is, yes, husband. Now, this is the reconveyance accepting that the loan has been repaid.
So according to you, everything was done in his own initiative by his own
initiative.
money.
Yes, there is only one document, one other document regarding the source of fund that I want to show. Those documents are annexed with the additional judge's brief. The 59 original receipts for repayment of the mortgage loan and interest.
Yes, Lal Bihari Mullik's signature is there.
Yes. There are 59 of them, my lord. If your lordship comes to the first document, at page 700.
Mr. Banerjee, I don't think you have a chance because I have to raise at 2:45. I have a division bench matter.
You'll show that.
I heard that.
Yes. Yes. Yes, my lord, I need not wait, my lord. I'm deeply up.
Even if I start, you will not be able to finish it.
No, no. I cannot be able to.
Yes.
Let me have a chance, at least to some extent.
All right. Yes.
These are 59 receipts. Your lordship will find 700 is a receipt issued by Lal Bihari as executor. But 701 is a receipt issued by Nandorani. Now these 59 receipts have as a bunch been exhibited as exhibit 44.
Yes, I've seen that.
Exhibit 44. Now now
you want to show this
I
mortgage
am-
was not a sham document.
yes, yes. I want to show that the source of fund is exclusively that of Shohodev alone. And I will take you to the deposition in a
Took
bit.
mortgage and repaid the money.
Yes, he took mortgage and repaid the money. Partly he contributed himself and partly was by way of a loan secured by a mortgage, which he repaid, and there is a reconveyance. Exhibit 45 is also an important document, Malak. It's a bunch of documents. Your lordship will find it in the original judge's brief. Defendants documents number 68, 69, and 70. Pages 687 to 691.
Yes. So this is torn. My copy is torn.
My lord, I'll supply. Essentially, I'll tell you what had happened. The income tax officer had issued a notice to Shohodev, disbelieving the loan, made an assessment, challenged by Shohodev in the appeal, where Shohodev succeeded and the loan was accepted. And there is also, and DD 70 is the document while during the pendency of the appeal before the appellate authority, the income tax officer had issued a notice to the certificate officer to attach Shohodev's properties for payment of income tax assessed. The purpose of these documents is to show that the question of law was also tested by the statutory authorities, and ultimately Shohodev succeeded in establishing before the statutory authorities that the loan was a genuine transaction.
But let me know one thing. You are the defendant.
Yes.
It is for the plaintiff to establish his case.
My lord, I am just being cautious. I will take your lordship to what evidence the
Irrespective of they are able to establish their case.
I am just being cautious because source of fund, they have said this property was purchased by Shohodev as we have paid 40,000 rupees in cash to him. And the cash comes from an iron chest, which apparently is still standing in the position where it was when they took out the money from that chest and gave it to him. Now that chest, he admits, is standing in 33 Mundal Street. He is depositing this in 2003. Therefore, the other part of Exhibit 45 is the sanctioned building plan which Shohodev obtained and thereafter broke the existing building, reconstructed a building and started living there from 1961. So therefore, 1951 question of giving money from an iron chest which was standing where it was in 2003 could not arise because in 1951 none of them were living there. It is admitted by the defendant's plaintiff's witness number 1 that in 1951 when this property was purchased they were living in 70 by 311 Jewel Garden Street. So the entire evidence of the plaintiff as to the source of funds is sham, and he admits in his examination that I have no single scrap of paper to show that I paid this 40,000, but I paid the 40,000. I took it out of that iron chest. Now, my lord, so I will, on the next occasion, I'll give your lordship better copies of these income tax orders because your lordship's copy is torn. But may I now take your lordship to the deposition on this issue? Kindly take the evidence of Guru Padamondal. Question 291 to question 301 in examination in chief. I am referring to another document being a part of PD 50 of the judge's brief of document, copy of which is at page 225 of the judge's brief of document. Please tell my lord, what is this document? This is a letter written on a postcard. Please go through this letter and tell my lord in what connection this letter was written. This letter was written in the context of proposal for purchase of a house by we, the three brothers. Money was collected and handed over to Sahadev Mondal for this purpose. Could you tell my lord the date of this letter? 6th October 1951. Could you tell my lord where this letter was written? This letter was written from Calcutta Registration Office. How can you say this letter was written from Calcutta Registration Office? This was written at the top of the right-hand corner of the letter. To whom this letter is addressed? This letter was written to my brother Mrityunjoy Mondal. Who is Mrityunjoy Mondal? He is my elder brother and a brother of Sahadev Mondal. Is he still alive? No, he is dead. Was he a party to the suit? Yes, he was the main person in the suit. Whose handwriting appears on this letter? This is in the handwriting of Sahadev Mondal. This is marked Exhibit W. Kindly have a look at this letter, my lord. It's at page 225 of the judge's brief. The English translation is there. Received information through Ketu Roy about your safe arrival. Please give information about the safe arrival of Gurupada. Please be informed that our deeds of purchase in respect of two houses being numbers 33 and 34 Mondal Street have been caused to be registered together on this day. On receipt of the information regarding the registration of the deeds, the tenant in respect of the house being number 33 came to me this evening to take on settlement afresh from us. I have told him that necessary steps relating thereto will be taken after the Pujos. Shochi left for home. The rest is not important. So this is the only document that they are producing in support of a claim that, and specifying the use of our to construe that this
Documents relates to mortgage and everything relates to 33 and 34.
Yes. And it could not have been written from the Calcutta Registration Office because the letter says the tenants came to me in the evening. Now, this is the only documentary evidence they have produced so far as 33 and 34 Mondal Street are concerned. Now, kindly take his cross-examination from question number 410. In fact, my lord kindly takes from 408. As your lordship found, 408. Kindly look into the document which was marked as Exhibit W in this proceeding. According to you, who has written this letter and to whom? This letter was written by Sahadev to his younger brother, Mrityunjoy, stating therein that the property had been purchased. This letter was written from the registration office itself. Do you find that in this letter it has been mentioned that the tenants of the premises number 33 went to the author of the letter in the evening of that day? Yes, they had approached the author of the letter for the purpose of renewing the tenancy in view of the fact that the owner of the premises had changed. You will agree with me that this letter was written by the author sometimes after the evening of 6th October 1951. That would be so, but he had written the said letter from the registration office on the said date as mentioned in the letter. Can you tell, my lord, in whose handwriting the words registration office in Calcutta as appearing in this document? It is in the handwriting of Sahadev. I know his handwriting. You will agree with me that the letter could not be written by Sahadev from the registration office after the evening of 6th October 1951. This letter was written on the 6th of October 1951 at the registration office, but I would not be in a position to say as to the time when this letter was written. This must have been written after the registration process was over. That would be in the night. I am suggesting to you that the handwritings are not of Sahadev. I deny that. You have alleged before my lord that Sahadev used to act as the Korta of the alleged joint family. Do you recall that? Do you recall that? Sahadev, everything was being controlled by him. In that event, I can also take it that according to you, Sahadev also used to collect the money which was received by the alleged joint family. Yes, that is so. He was the karta of the joint family in this capacity. As much as such, he used to do whatever was needful. In that event, I can also take it that there was no question of either you or Mrityunjay collecting or handing over any money to Sahadev. Sahadev was the karta of the joint family. We used to respect him like our father, and whatever earnings we have, we used to hand over to Sahadev, and he used to spend it in his own way. We have entire faith on him. Your evidence is that you yourself used to collect your own earnings. There was nothing as my own income. The earnings were out of the businesses which was done jointly, and whatever be the income from out of the business was handed over in its entirety to Sahadev. You will agree with me that there was no question of your collecting any money. Everything was collected by Sahadev. If everything was collected by Sahadev, in that event, there was also no question of your handing over any money to Sahadev. All collections were made by Sahadev himself. Can you tell, my lord, how was the consideration money for purchasing premises number 33 and 34 Mundol Street paid by Sahadev? The consideration money for the purchase of premises number 33 and 34 Mundol Street was handed over to Sahadev by us from out of the income from our native place and from out of the income of Annapurna vegetable stores jointly. Do you know the consideration which was paid by Sahadev for purchasing the said premises? Consideration money for purchase of premises number 33 and 34 Mundol Street added to rupees 36,550. And the entire money was paid by you to Sahadev. That is your evidence. We had given an amount of rupees 40,000 from the funds of the joint estate to Sahadev towards purchase of the
Your
said.
point, what you argued is in page question number 429.
Yes. Yes, I was just coming to that, Manoj. From 425 to 29, those questions. The mortgage was put to him. A kind 429. This amount of rupees 40,000 was kept in an iron chest, which even today stands in the same place where it was. Dada used to collect all money from us and keep it in that iron chest. Yes. Now, the plan obtained by Sahadev after purchasing the premises for demolition and reconstruction is also a part of Exhibit 45. So therefore, in 1951, there could not have been an iron chest at 33 and 34 Mundol Street, at least prior to purchase thereof. So this entire story of 40,000 rupees coming out of an iron chest or coming out of the income or sale proceeds of the goods sold at Annapurna vegetable stores also
Point
does
is
not.
that in an iron chest, even today stands in the same place.
Yes.
This deposition was made on
This deposition, Millard, was made on 18th September 2003. Your Lordship will find from question 408, Your Lordship will
18
find
September 2003. So on that date, there was no iron chest because the property was reconstructed.
Yes.
Demolished and reconstructed.
Yes.
So it's totally a false statement.
That's a false statement. Now, Millard, instead of reading the other questions, kindly take a note. The relevant questions are questions 445 to 445 to 471, 658 to 665, 730 to 733, and 881. These contain, Millard, the entire cross-examination of the plaintiff's witness number 1 on this issue. All the documents that, Millard, I have shown Your Lordship, which have been exhibited as defendant's documents, were confronted to the witness.
Where that iron chest is situated, located?
It's in 33 and 34. It is still there today.
Where he has said?
Yes.
Where he has said it is in 33 and 34?
On 18th September 2003, he is deposing that he took out the money from the iron chest, which was kept at the location where it was kept on 18th September. On 18th September, it was only in 33 and 34.
Because
Because his deposition is that it is in 33. Kindly take 429 once again.
this amount 40,000 was kept in an iron chest,
Chest, which even today stands in the same place where it was.
which place are you referring to?
It has to be 33 Miller because Ratan Sarkar Garden Street was a tenanted place which is no longer there. And that your lordship will find if your lordship sees question 446. 445, he says when this premises number 33 Mongol Street purchased by Shohadeb in the year 1951. 446, at that point of time, where was Shohadeb residing? He used to stay in a rented house in Ratan Sarkar Garden Street. When premises number 33 was purchased by Shohadeb, who was residing there were tenants. Premises number 33 and 34 were purchased on the same deed and they were situated side by side and purchased under the same deed of sale. When did Shohadeb shift to premises number 33? I don't remember because the incident is of a long time back. It was obviously after 1951, that is so. But you remember whatever happened in 1951, but you do not remember what happened thereafter. You know about the incident so that I will be about to tell. You remember that the premises is purchased in 1951, but you do not remember when Shohadeb shifted to that premises.
The house 452. He said he repaired the house.
Yes.
6 and 7 years after 1951.
Correct.
He got the house repaired.
Correct. Now kindly see page 454 onwards. We say that mortgaged.
Denied mortgage.
Yes. Now kindly come to page 450, question 459. You have alleged that you and Mrityunjay contributed for purchasing premises number such and such. Do you recall that? Both of us paid a sum of rupees 40,000 in respect of purchasing premises number such and such, including the costs and expenses. When was that? I have stated this in my evidence earlier in the year 1951. I have stated everything in my deposition earlier. In 1951, 40,000 rupees was a substantial amount. Do you agree with me? Yes, that is so. I have stated this before. Have you produced a single scrap of paper to prove that any amount was paid or contributed by you or Mrityunjay?
He said our home.
Yes. No such paper has been produced in the said proceeding. Money was paid by us. We, the both brothers, out of iron chest of our home to Shohadeb for purchasing the said premises. Where did you get 40,000 rupees? Said money was from our joint family business and it also included the income that came from the property in our native village and also the income that came from Annapurna vegetable stores. I have said all these in my earlier evidence. Have you produced the books of accounts of such alleged joint family business from which it can appear that you have accumulated rupees 40,000 in the year 1951? I have not produced any such books because such books are lying with Shohadeb. I am suggesting to you there was no such alleged joint family. Then, my lord, we put the mortgage to him. In answer to
He
question,
admitted execution.
yes, but in 467 he admits the execution and says this is a false document. 468 he admits the signature of Shohadeb.
Yes.
In 470, do you find in this page Shohadeb acknowledged the receipt of rupees 20,000? Might be, but this is a false document. Again, 471, he identifies the handwriting on the deed as that of Shohadeb. Now, thereafter, kindly take question 658. According to you, premises number 33 and 34 Mondo Street was purchased on 6th October 1951. Am I correct? I do not remember. Who paid consideration money for purchasing the property? Money was given from joint family fund. Did you or Mrityunjoy personally contribute any money for purchasing this property? Myself and Mrityunjoy gave money for purchasing the said property from the joint estate in the hands of Shahodev. How much money did you and Mrityunjoy give to Shahodev? We gave total sum of rupees 40,000. Did you recall when you allegedly paid the sum of rupees 40,000? I cannot recall the date. Did you allegedly pay this money on the date of purchase? I cannot recall. The day when this property was purchased, were you here in Calcutta? No, I was not in Calcutta. Was Mrityunjoy in Calcutta on the date of purchase of said property? No, he was not in Calcutta. Then my lord kindly comes to pay 7th.
To come on the next with the notes of argument, referring all the evidences.
Notes on argument I'll put in at the end because this is the there are several other properties to be gone into. I'll give you a lordship a comprehensive notes on argument
With reference to the evidence.
Yes.
Exhibits.
Evidence, exhibits, questions, everything.
Come on the next date.
Very well.
Heard in part. Now the learned counsel for the defendant in part. The date was. Further argument is deferred to. 30, would you come on 30?
30th. Yes, my lord.
30th August. Mr. Ghosh, not today.
Tomorrow then, the witnesses here. Come tomorrow.
Complaint may be kept anytime 2 weeks after, my lord.
That would be better.
Yes, my lord. I've been told my lord is unavailable.
Another petition has been made by the defendant on
Yes, ma'am.
as a preliminary point. Your lordship had already decided our witnesses here. Let it be tomorrow. If the petition is pressed, we'll.
My lord, it would be best if it is heard compositely.
On the last of
which one?
Our petition, my lord, along with the suit, the witness action, it's better if it's heard compositely, my lord. That's my.
How it can be heard compositely. One thing.
But as far as my witness is concerned, your lordship will recall on the last occasion, Mr. Mitra was in problem. They took an adjournment. He had come. He's come again today. So.
Come on 28th August.
And the application they have moved. They have taken
Yes,
out
my
another
lord.
application, again preliminary point.
That will go on. That will go on.
28th.
Let the evidence be
Yes.
taken. At the same time, that matter will be also heard.
So my lord will record that too. The applications will be taken up on the 20th.
20th August, affidavit in the application may be completed. If they want to file an
Let
affidavit.
them move. It's not, it's the same point, my lord, again
No, no,
preliminary
this is
point
not
on
a limitation.
limitation.
This is
My
not a
learned friend
limitation.
had conceded that limitation was mixed question of fact. and
I never conceded.
It was, that was what was argued,
All right.
only jurisdiction was
Have you
argued.
given a copy?
We
Yes,
have,
Have you
yes,
that
sir.
application with you right now?
Petition, yes,
So move it then.
yes. I've given the copy, sir. Sir, where is it? Sir, we just have the one.
Where is that application?
Yes.
my lord, we will take it up. We won't use an affidavit. Your lordship
Very
will
good.
hear
Then
us on
then
that
all
day.
right. Then
I am fixing it on 28th.
Yes,
Come
yes.
with the exchange of affidavit if you desire.
Very good.
GA 14 of 23 is filed.
কিন্তু কোনখানে মেনশন অন করলো তো আমায় বলে কোনতে মেনশন করছে না নানি কেন মেনশন করলি ও বলছে 28 তারিখ আমি তো বললাম নক করে নক করে ঠিক আছে ওটা আমার ভুল আমাকে ভুল বলছে আমি মেনশন কথা কথা আপত্তি তাহলে করো তাহলে কেন মেনশন
With certain prayers. Copy served to the plaintiff. Plaintiff. Affidavit in opposition, if any, be filed within 1 week. Full stop. Affidavit in reply, if any, within another week. Let the matter appear in the list on 28th August.
Along with the, also my witness also will come back on the.
The suit will appear in the list on 28th August under heading witness action.
Grateful.